Well, Binger is trying again to win at something. The judge has pretty much slapped him around, and it's not because the judge doesn't like Thomas Clair Binger, although he probably doesn't. It's just that Thomas Clair Binger is a moron. He keeps bringing up motions that a school child could look at and say, yeah, that ain't going to fly. Well, he's trying again. And in this case, it concerns the testimony of Amanda Franco. She is a Kenosha Police Department officer that the defense wants to question. Binger does not want her questioned, and now he's come up with the motion to have her stricken from the witness list. How do you think he's going to do? Hello out there. I'm trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
All right, Thomas Clair Binger, give it your best shot.
Your Honor, I filed this motion regarding one of the witnesses that's been listed by the defense, Amanda Franco. The basis for this motion is that the officer here has virtually no connection to the case.
Yeah, we can't have that. Keep in mind, this is the same dude that put 43 police officers on the witness list. And now he's coming around and saying, well, we have to have this one officer stricken because she doesn't have a really strong connection to the case. But all those 43 police officers do, right?
The officer encountered the defendant on the evening of this incident, had a couple of very brief and cordial conversations with him because she had recognized him from the incident from June of last year, which was the subject of our other acts motion. And
what he's talking about is that schoolyard fight that Kyle got into.
the court has already ruled on that motion.
Yeah, that's right. The court has already ruled on that motion. In other words, the court really doesn't want to hear about it anymore. Get a clue, Thomas Clair Binger.
The court has already ruled that the state is not going to be allowed to introduce evidence regarding that incident. And just to refresh the court's memory, that was an incident in which...
Oh, to refresh your memory, which means that I'm salty over that and I want to go back through and cry some more and tell my story and tell how bad Kyle was when he attacked that girl on that day.
There's an allegation that the defendant's sister was involved in a one-on-one fight with another female, and during that fight, the defendant intervened on behalf of his sister, essentially turning it into a two-on-one fight. And I argued that it went to the issue of self-defense because the defendant was purportedly trying to assist his sister, but a two-on-one fight is hardly appropriate.
Oh, that's right. It's so unfair. If you see your sister getting into a fight with somebody much bigger, you should not intervene because that makes it 2-1. You should just let your sister get pummeled. Listen, these fights are not about fairness. These fights are about winning. When you see your sister getting in a fight, you intervene. It doesn't matter if it's 2-1. This is not a game. It's not a competition.
This was recorded by some other individuals, and that video was submitted to the court as part of the motion. It's my understanding that after that video ended, there were subsequent interactions between the defendant and the individuals who made that video.
All right, here we go. I know some of you were thinking, oh, come on, you're being really hard on him. He doesn't really want to talk about that fight. He's wanting to get to the real guts of the matter with that Amanda Franco. Really? He now wants to talk about discussions between Kyle and the people who took the video. Of what possible relevance is that to her testimony? The judge has already ruled that that whole fight thing is not relevant. So Binger just simply wants to tell his story again. And part of this is propaganda. He wants to go through, walk through the story again because he knows people are listening and people will hear, oh, he got in a fight and he hit another girl? Oh my God, what a terrible person. That's what Binger's trying to do here. And the judge is not going to have any of it.
we did go through this before.
Correct.
So get to the heart of your motion.
Certainly.
In other words, shut up about the damn fight.
The heart of my motion, Your Honor, is that the court has already ruled that that incident is not going to be introduced into evidence at the trial. The defense, by calling Officer Franco, I believe, would be seeking to relitigate that prior incident because,
You know that the defense is going, oh, really?
as I said, her only connection to this case is the fact that she recognized the defendant from taking a statement from him regarding that prior incident. And since the court has already excluded it as part of the state's case, I believe it's only fair that it be excluded as part of the defense case.
It's not about fairness. This is not a game. Yes, you got your motion struck down. That doesn't mean that the judge has to throw you a bone. Furthermore, it doesn't matter that the police officer knew Kyle from that incident. A child can see through this argument. And that's the problem I have with Thomas Clair Binger. He keeps throwing this thing up in front of Judge Bruce Schroeder. Schroeder is a smart dude. He is not going to fall for this crap. This is what I call the, you really think that the judge was born yesterday and that this is going to get past him. It is not.
Thank you. Mr. Sharafsky.
Judge, I would never relitigate a motion that I've won.
Chirophacy had been waiting for the last 5 minutes to say that one.
So
even granite face Mark Richards is laughing.
I understand, having been a lawyer for a little bit, that if I open a door or I do something that would potentially bring something up that the court has already precluded, I guess I do that at my own risk. That's not the goal. I would never do that. It makes no sense based on what Mr. Binger has told you today that I would ever try to do that. But she is a witness. She was present during the incident.
In other words, just because she interacted with Kyle during an event that has been excluded from the trial doesn't mean that she cannot be questioned about events that took place that night. Yes, she cannot be questioned about things that took place during the fight 2 weeks earlier, but they can question her about stuff that took place that night in Kenosha. Binger's argument is so illogical. Suppose that Amanda Franco had overheard Kyle Rittenhouse saying, I can't wait to kill somebody tonight. Ooh, I've been itching to kill people tonight. Do you really think for a moment that Binger would argue that she cannot be questioned about that because she interacted with Kyle 2 weeks prior in an event that was deemed inadmissible? Who here believes that? But that is Binger's argument. It is stupid beyond belief, and a judge does not fall for it.
So if we believe, I've never had this before, where we believe that she may have relevant information as somebody that was present at the scene, that she be preemptory barred from testifying because they think that we're opening a door that I have no intention of opening. So I think it's only reasonable that the court allow her to testify if she has relevant information, or 90401. And if it is, then she'd be allowed to testify about that. I have no interest in bringing up to relitigate something that has already been ruled in our favor.
So in other words, Binger really can't be concerned about the fight thing. He's claiming he's concerned that this police officer is going to discuss matters related to the fight, but if you're the prosecution, that is exactly what you would want her to do. If the defense asks her about that fight, it opens her to cross-examination, allowing the prosecution to bring up the whole fight, which is what they wanted in the first place. So Binger's argument is so inane, and Chirophacy points it out. He's saying, look, the last thing I would want to do is to question her on that fight. So what is the prosecution so concerned about? And the answer is, It's not about the fight. It's about what she's going to say, what took place that night in Kenosha. It's obvious.
Thank you. The motion actually seems to encompass not just the incident of July 1st, but also contact that allegedly was had between the accused and Officer Franco on the 25th of August. So
You see the look? Judge Schroeder is just totally puzzled. What he said is, look, your motion doesn't just concern fight. If it did, the judge would say, well, okay, that makes a good sense. You don't want her testifying about what happened at the fight, although it would work in your favor, but I would get it. At least it would make some logical sense. But you're trying to exclude her testimony about what happened in Kenosha on August 25th. Makes no sense whatsoever. And he's scratching his head here, trying to understand what Binger's motives are, but it's clear what Binger's motives are. He just wants Amanda stricken from the witness list, and he's willing to say anything to do that.
assume that if you wanted to get the evidence in on your initially as evidence of other crimes, wrongs, and acts, and I ruled against you, but if the defense wants to go into it, then you probably get your way and it'll come in.
Exactly. The judge is saying, I don't get it. You wanted the fight included. And if she gets on the stand and the defense goes into the fight like you're worried about, you would get your way. So why are you wanting her not to be on the stand? He's just totally befuddled.
With respect to the incident that allegedly occurred on the night that the shootings took place, then what is the reason that you think that I should suppress that?
Because it has no relevance. The report that Officer Franco submitted regarding her interactions with the defendant is very brief and simply says she had 2 brief but cordial interactions with the defendant after recognizing him from that prior report.
Okay. If your motion was really about relevance, then stick to that. Make a point that says, hey, she doesn't really have anything of value, therefore she shouldn't be on the witness list. To bring up the fight makes it appear to the judge that you're trying to pull some sort of shenanigans here. He wants her off the stand because she's going to say something that's going to hurt his case. And therefore, it is probably relevant. Now, you might be wondering, well, wait a minute now, just because it hurts his case doesn't necessarily make it relevant. That's correct. But then you have to go to the point of what is she going to claim? And is that relevant or not? He's trying to have it stricken because of some fight that took place 2 weeks prior.
Or from that prior incident. She would not have known him otherwise. She, I'm sure, was out on the streets that night encountering probably dozens, if not hundreds of people, some of whom she might have recognized, some of whom she'd probably never seen before.
Okay, so she happened to recognize him from the previous fight. What difference does it make why she recognized him?
She only interacted with the defendant because she recognized him from that prior report. Otherwise, I doubt she would have had any interaction whatsoever. So I don't know what the relevance of this is, and I guess if the defense wants to introduce this evidence, I would ask that there be some sort of offer of proof as to what the relevancy is of it.
Again, if Amanda Franco was going to go on the stand and say things that would help the prosecution, do you think he'd be making this argument? No.
This is what I apologize, everybody. What do you want for $50,000, right?
Are you talking about the lawyer or the technology?
He's charged with multiple counts of reckless behavior, right? And so when you are listening to the evidence and the jury is making a determination as to whether or not that conduct is reckless, all the facts and circumstances per the jury instruction come into play. What he was doing, how he was doing it, how dangerous it was, the recognition of that danger, and him having contact with police officers that evening, them assessing that behavior, allowing him to move on with his night. Certainly it's relevant to his state of mind as it goes to whether or not that behavior was in fact reckless, as that is defined by the jury instruction. So it's relevant. And if it's not, Mr. Binger can ask that it be stricken. You can take him up on that. But his contact and Mr. Rittenhouse's contact and what he's doing with law enforcement and the contacts he has with them, under the idea of whether that behavior is reckless or not, all of those contacts are relevant under the jury instruction. Simple as that.
I think I don't see any reason to anticipate trouble. I can understand that you might be apprehensive as to some misuse of some kind of testimony along this line, although I'm certainly not suggesting that I see misuse coming, but so you can contemporaneously object. I think that's probably the better way to handle it rather than for me to slam the door on them before even hearing what purpose they want to use it for.
Your Honor, this does tie into the motions in limine that I filed, and I appreciate Attorney Traucy making explicit what I have long suspected, which is that this is going to be a trial over the police department's activities that night.
As opposed to the crap you're trying to pull off?
The argument here that was just put on the record is that the police saw the defendant that night, didn't stop him, and so therefore there's some culpability on their part, or some sort of implicit approval of his activities that night.
Oh, they didn't say anything like that. Where did that come from?
Or express approval of his activities that night. That's not relevant, Your Honor. The police assessment of the defendant prior to him killing two people does not have any bearing on whether or not his actions in shooting and killing two people were lawful or reckless or not. The jury.
All right, maybe if you had opened with this argument, the judge might have at least considered it. Of course, you would have to know what Amanda Franco is going to testify on. You haven't even brought that up. And the judge made note of that. I'm not going to slam the door on a witness when I don't even know what she's going to testify on.
Is the one who's going to make the ultimate determination there. And whether or not police officers saw him earlier in the evening when he wasn't shooting and killing people, and whether or not they stopped him or didn't stop him or said anything to him or didn't say anything to him is not relevant to the ultimate decision in this case. But I think the defense argument here is pretty clear. They want to say that because police officers saw him and didn't stop him, somehow that makes him lawful, that makes him justified.
They never said that.
And I don't think that's the case because, number one, that's not the determination here as a matter of law. But number two, the officers didn't see him shooting people. They didn't see him killing people. They saw him at a time in the evening when he was on private property guarding a building, a business.
Notice how it has shifted now. I thought this was all about the fight that took place 2 weeks prior, and that's why she shouldn't be on the stand. What happened to that argument? It's completely morphed. He's created a new one on the fly.
And that's different than the activities that are alleged to be reckless here. So I don't think there can be a connection here between what the officers may or may not have done earlier in the evening and whether or not the defendant's ultimate actions in shooting and killing two people were intentional or reckless or justified.
What about those 43 officers you put on the witness list? You're making a claim here that the interactions of the police officers shouldn't matter. Police shouldn't be involved in this. But he's got 43 of them on the witness list.
So I think this is exactly where I thought that the defense would be going. It's one of the subjects of one of my motions in limine, Your Honor. It's, I believe, motion number 3, and it seeks to just make sure.
It's number 4.
I'm sorry, I've got to misnumber it. It's number 4, and that's part of my motion in limine here, which is that the defense should not be allowed to, actually no, it's not number 4.
Okay. He's got 5 motions in total. He's going to get it right sooner or later. We have faith in him.
It's number 5, actually. It's the motion to eliminate talks about whether or not anonymous law enforcement officers made statements earlier in the evening regarding the defendant's activities, or whether or not they talked about their plans in terms of crowd control or things like that.
The judge is thinking, wait a minute, I thought we were talking about motion number 1. That was about a schoolyard fight that took place, and the whole reason why we can't have this police officer on the witness stand was that she was involved in that. Then it morphed into the defense wanting to use police officers' testimonies when in fact they did not see the shooting. And now we've morphed into a completely different motion.
And this is not a trial about the police activities. It's not a trial about police tactics.
Yet we have 43 police officers on your witness list. But it's not about police activities, no.
It's not a trial about whether or not law enforcement that night took action or didn't take action. This is a case about what the defendant did that night. And I'm concerned that this is going to be turned into a trial over what law enforcement should or shouldn't have done that night. And I don't think that's what this court or what this trial should be deciding.
Okay, that may be a good point. Your argument supporting that point sucked. That sucked. You got in trouble with that whole schoolyard fight argument, and now you're creating an ad hoc argument about this whole thing about the police officers. You're rambling. You're all over the place.
Oh, are we arguing the motions and eliminating now?
Yeah.
Okay, very well. So number
Sharophacy is so confused. Like, wait, where are we? Because we have been all over the place here.
no, I guess we're just doing number 5 right now. Oh, I don't need it for this one. So
Yeah, he says 4, you say 5. It's like Protestant versus Catholic with the 10 Commandments.
So this is my understanding. So in the video, there is a statement by a police officer who says, an unidentified police officer saying, we appreciate you guys, we really do.
Okay, so we moved on to motion number 5 because Binger meandered. Again, I'm saying it. The guy comes in unprepared. He should have known that the judge was not going to go for this schoolyard fight argument. Anybody can see through it. And he should have known what to do when it got shut down. I'm telling you, the worst lawyer I've ever seen. If he wins this case, it's only because some evidence came up that was so damning that not even Thomas Clair Binger could lose. Like my video, subscribe to my channel.